Thank you very much, Madam Speaker. Madam Speaker, it is again a privilege to be able to stand in this honorable place and to represent the good and the special people for East Grand Bahama. Madam Speaker, as was said by the member for St. Anne's, those of us on this side agree, support, prepared to support both of these pieces of legislation. I do not intend to speak very long, just to make a few short points. You know, you don't ever make promises you can't keep, but I will do my best. Madam Speaker, the concept, I believe, of this first bill, which is introducing the election for a trial alone, or trial by judge alone for indictable offenses, I believe the concept has wide support. This, as was said by the member for Cat Island, that it is not a new concept, that I believe the first, or the Constitutional Commission, I believe in 2012 or 2013, also spoke about this. They spoke about the constitutional right to trial by jury. And this concept, I believe, was also discussed in that commission. Also, we have persons, very prominent persons, very prominent judges who have publicly spoken about this and have publicly given their support, given their go-ahead for this concept. One of those persons is Dame Anita Allen, who, and I'll quote her when she said, additionally, I propose two other suggestions. The first, which was advocated by Sir Burton Hall some years ago, is to provide in legislation the option by judge alone to persons charged with offenses such as murder and manslaughter. This will alleviate the need for some jury trials where accused persons choose that option and may help to decrease the backlog of cases waiting to be tried. She then says, alternatively, if there is an appetite for a referendum to amend the Constitution to remove that, the right to jury trial, in which case criminal defendants would have no choice but to be tried by judge alone. I do not believe that we would support any constitutional amendment to do away with the right to be tried by jury. And I believe the member for Cat Island said that as far as his government is concerned, that right for trial by jury will be protected. So we support that. Also, as was said also by the member for Cat Island, was that recently the Eugene DePuch Law School, and I believe we need to have even more of these type symposiums, but the Eugene DePuch Law School also had a lecture series which involved current and former Chief Justices. I'm not sure whether this was the first time that you had former and current Chief Justices on, has it happened before? I think this is the first time that you've had current and former Chief Justices to discuss issues relating to the judicial system. I think it was a dynamic educational forum that we need to have even more of. Also, what appeared to come out of the discussion was as an agreement to this concept, that all of the former Chief Justices and the current Chief Justice seem to all agree that this is a positive thing to do, and this is the way that we ought to move forward. So as a concept, I believe there's wide support for this. And so we on this side support the concept. You know, there's always, as was said, you know, the devil is always in the details of these things. And I believe there may be some challenges with respect to persons who've I think the point that the member for St. Anne's made, where if you have someone that elects a trial by judge alone, and at some point changes his mind, and because of what the legislation says, he is now bound to continue with having a trial by judge alone. I'm sure that that may be tested, but I take the point that Freetown has made that this again is not a new concept. That you have where you have an electable summary where offenses are triable either way, and if you elect summary trial, then you have in essence elected a trial by judge alone, and those matters have seemed to continue smoothly. I don't recall there being a constitutional challenge where somebody has said that I've elected a trial by a judge alone in the magistrate court, and I'm entitled to have a judge. I'm entitled to have a trial by jury. So I think there will be challenges, but as I suspect these matters go, I believe the concept will survive even if there are these challenges. But I think the more important question would be, once we introduce this, will persons actually use it? So will persons who are tried with very serious matters, will they, in essence, elect to have a trial by a judge alone? I don't know the answer to that question. I don't know if any of us have the answer to that question. I suspect that it may not be picked up on a lot. I suspect that persons have become comfortable with the concept of having a jury. I suspect that persons may look at this, from a purely numbers point of view, that it may be easier to convince 1 out of 12 or 1 out of 9, as opposed to convincing a judge alone, who sees these type matters on a daily basis, and can look at these things clinically as opposed to emotionally. Having a jury has its advantages and its disadvantages, and so I suspect that persons may be more comfortable with the existing system. I think a lot of education is going to have to be done with society, because again, the society has become comfortable and used to having, for serious matters, there is a jury. And so the society, I believe, will have to also understand that you now have a choice, and even when it comes to the advice that lawyers give in these circumstances, because again, the point that a member for St. Anne's made, not all advice is good advice. And just because a client receives legal advice does not mean that that is good legal advice. So again, there may be some guidelines in terms of, for lawyers, this is the considerations that you should be taking. These are the considerations you should have when you make these type, or when you provide these advice to clients. Also, Madam Speaker, productivity really is, we should focus on being productive as opposed to being busy. And while a lot of what the government may be doing in terms of crime prevention and fighting crime may be busy, we need to also make sure that your busyness is also being productive. And so while, yes, this is something that has been suggested. This is something that has been agreed to. And yes, we have no objection to proceeding with it. I think, again, we need to also, when we put this in place, be able to look at the data. So in 6 months, a year, look at the data to see whether or not this is actually productive, whether this is actually working. And then we can make the judgment call based on that. Also, Madam Speaker, we also need to look at why it is that persons are shying away from being jurors. Do we need to increase the stipend that jurors get? Do we need to make it easier for jurors to have access to, being protected? I think we need to look at why jurors are reluctant to serve, or why potential jurors are reluctant to serve. And we need to actively be able to address those type issues. It's one thing to take it out of the realm of jurors, but we still cannot ignore the fact that jurors find it where they are reluctant to serve as jurors. So we need to look at that, look at whether the stipend, we need to increase the stipend. And as I said, this is not a silver bullet. I mean, I don't want anybody to believe that this is going to solve all of our crime problems, or this is going to have a significant impact. But this is one of the tools that can be used to assist in fighting crime. Things like we need to look at having a new Supreme Court building so that we can increase the amount of courts, we can increase the amount of judges. I think we need to look at that as well, even in Freeport, as well as in Nassau. It might even look at Abaco, having a Supreme Court that sits in Abaco as well. But I think we need to look at having a new Supreme Court building, new Supreme Court facilities. Madam Speaker, I was out visiting constituents on last weekend, and one of the ladies had said to me, Mr. Thompson, I need you to tell Parliament that we need stiffer penalties when it comes to sexual offenses. So I did tell her that on the next occasion that I was in Parliament, that I would make that call, because I agree with her. She said one of the things that I asked her if she had any concern. She said one concern that she had was that we need to have stiffer penalties when it came to sexual offenses. And I 100% agree with what she said and endorse what she said and make that recommendation. Also, Madam Speaker, we need to look at things like the juvenile court. When I was in practice dealing with criminal matters, the juvenile court sat, they had one hearing per month in each court. Now, I'm not sure whether that is still in existence, where the juvenile court sat once every month. But I think we need to have a standalone juvenile court that can look at how we deal with criminals or potential criminals who are under the age of 18. It should be a special court. It should be special circumstances that you are able to deal with these young people, because they are, in fact, young people. Social services, as was in the past, they are involved in this juvenile court, but I think we need to have them full-time, standalone, to be able to deal with juvenile matters. And the same, I believe, can be considered for sexual offenses, where we have a separate court that deals with sexual offenses. Madam Speaker, the second act, or the second bill, is with respect to the rules. Again, we don't have any objection with respect to that second bill. The only issue that I would advocate for is if there are rules that are contemplated to be introduced, that those rules that are contemplated to be introduced, that they be put out for consultation before they are implemented. As was done by I believe the Supreme Court with the Supreme Court rules, they were out for some time. It was really an overhaul of the civil rules. And I believe that if we're going to do the same with respect to criminal rules, that it should be put out for wide consultation. The bar should be consulted. Public should be consulted. All of the stakeholders, the police, all of them ought to be consulted, because I believe all should have a positive feedback, or should be able to make a positive feedback, and that, again, would make the rules better when we all have had an opportunity to contribute to the rules and to make them better. Madam Speaker, I will end on what I believe the second recommendation that Dame Anita said. The second recommendation that she said was, and I'll quote what she said: "The second suggestion, which I apprehend abolitionists will find unpalatable, is a more aggressive approach by the prosecution to apply in appropriate cases for the imposition of the death penalty on conviction of murder." Madam Speaker, I would agree with Dame Anita's assessment. As I don't believe that we as a country should remain in the status quo, meaning either we are going to press forward and begin to look at whether or not and how we are going to move forward with death penalty cases, or if we are not going to move forward with death penalty cases, then we do away with it. But I am one of those advocates that it is on the law of the land. I support what she said in that a first step would be for prosecutors to look at appropriate cases and to press for, in those appropriate cases, to press for the death penalty in those cases. Well, if they have, wonderful. But I don't believe they have. And so I think that prosecutors ought to, if they have, as I said, if they have, excellent, wonderful, continue to do so. I haven't seen the fruits of it, but I don't believe that they have done so. I believe that, unfortunately, the status quo sort of has become the norm. And I believe that we need to actively look at these active cases and make the decision which is appropriate, and then press to proceed which is appropriate. Now, I also understand that there are a number of legal hurdles that have been put in the pathway to actually proceeding to a death penalty. So I also believe that we need to look at what are the ways that we can address the law, and I know this may have been done in the past, but I think we need to take another look at it. What are the ways that we need to either shift our system, change our laws by way of legislation or way of rules or time frames or whatever those things need to happen in order to press this button forward. But I think we just cannot remain the way the things are, that we need to actually press forward, even if we put a commission together that will look at how these laws, what the Privy Council has said, the state of our laws, and what we need to do in order to press the start button to move these things forward. If we stay the same and we just don't do anything, nothing will happen. But I think we need to press forward and move ahead when it comes to the death penalty. Again, to say, oh, yes, I believe in the death penalty, yes, we should proceed with death penalty, knowing that there are legal hurdles in the way, just saying that is not sufficient. But actually, we need to put action behind we need to put action behind the rhetoric. We need to put action behind that rhetoric. Unfortunately, we need to put action behind that rhetoric. And so I think
That was not a trap.
we need to make sure that we need to make sure that we have some very smart people who can look at what the law is and who can make active recommendations on how we proceed with that. One, again, recommendation that I heard, I think is it may be a very positive recommendation that I think we need to look at and have some wide consultation about as well. And so, Madam Speaker, that's all that I say. We support these pieces of legislation. We think consultation needs to happen with respect to any potential criminal rules. And this is just one of those tools that needs to be put and needs to be implemented. We need to look at putting it in place, but we need to look at the data as to whether or not people are actually using it. Because if people don't use it, then really, it's just a law, or it's just a piece of writing on paper. So we need to make sure that people are actually utilizing it, we reap the benefits of the potential benefits of what it can. Thank you very much, Madam Speaker.
Thank you, Honourable Member. The Chair recognizes the Honourable Member for Freetown.
Speaker, I didn't mean to interrupt. I didn't want